There's the microphone. All right, I'm going to just leave this running for a minute or so. People that might want to sign on. See, we have some people already, which is great. And anybody who is signed on to watch this right now, just, if you notice, there should be some kind of pad to the right side of your screen. Click into like the chat portion so I can hear that, so I can know that you can hear me. So I sent a message out to the audience. Actually, I want to apologize too for those that are signed on. It seems like I was maybe a minute late, and I didn't expect that many people signed on before me. I don't see anybody responding. Okay, good. So at least somebody responded. They can hear me. So I'm going to assume that everybody can now hear me. All right, so let's jump in. Good evening. Thanks for tuning in. This is the Micklin Law Group's monthly webinar series. Tonight it is on the 12 tips for men who file divorce over the age of 50, or as we call a silver divorce. This is me. For those that haven't worked with me, my name is Brad Micklin. I am the managing attorney and lead attorney managing member for the Micklin Law Group. We are a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices in Nutley, Montclair, New Jersey. Now, technically, this is being done during the sort of post-quarantine time, so we are working remotely with no contact electronic divorces. So I'm doing this actually from my home. People watching me on Facebook can see that this obviously isn't a law office behind me. But our offices are still operating. We are operating remotely, and we make periodic visits to the office to meet with clients if need be and to gather documents. For those on my webinar, this is a handful of awards I received from clients and other organizations. And you'll see these are on my website where they have the selection criteria so you can read a little more about them. I don't put these up to impress people. I put them up to impress upon you that I do have a good sense of what I'm doing as a practitioner. I do care a great deal about what I do in my practice and how I serve my clients, and I hope and believe that these awards indicate that. Also, I've been fortunate to receive a lot of media requests, a lot less since the quarantine hit because there's just a lot less media appearances for us. But here are some of the ones I've done. I've been on Inside Edition, Larry King, I-24, Fox News. Again, not trying to impress people, just showing that I do work hard and I have been around for a long time. I think and hope that you can trust in the opinions that I'm giving you today, as well as the advice that I give to my client. So before I jump into the webinar and give you the information, let me give you a little bit of a expectation in case this is the first time you've tuned in. This is obviously being recorded live. I expect and plan for a 60-minute webinar. Sometimes it's more, sometimes it's less. Hard to say. This one I had a feeling may be much longer. Not it's going to be much longer, but this had more information and slides than many of my other webinars. There is a chance I'm going to cut it short in the middle and finish it for my next webinar because I don't want to make something more than an hour long. I don't think people are going to want to sit for that long. So we'll see how it goes. Either way, hopefully you get information you need, even if you can't make the second approach or the second listing. Also, this is always simultaneously being published on my Facebook page if you're close enough with me that you want to send me a request. It's also my YouTube page, usually within a week or so, and my website. So you can watch it elsewhere if you need to review it, or if you can't stay on all the way through tonight. Also know there's a panel, should be a panel on the right-hand side that will allow you to ask questions. I don't believe, and I have to check this, but I don't believe anybody can see anybody else who's attending. So keep your name confidential, not only for your attendance, but if you post any questions. The chat panel has a section for questions. I urge you to write down any questions. You know what? I just saw somebody said they can't hear me. So I'm going to ask again. One person said they could, one person said they couldn't. So I apologize. I don't want to rambling if nobody can hear me and have you sit listening to an empty screen or watching an empty screen. So the person who is going to send a message to one person said that they can't hear me. Some are saying it's off a bit. I'm really not sure. I want to run another quick search. Message, can you hear me? Now, it could be, look, I'm in my house. It could be that I have a bad connection. It could be that you're in your house and you have a bad connection, your internet's weak. I don't know. I just want to make sure before we start moving along that at least my audio is on. Testing, 1, 2, 3. It's showing that my mic is on. I hope those that are watching can hear me. And those on my Facebook page, sorry for the delay, but I'm going to move along with the hope that you can hear me. So I'm just going to check real quick. Not getting responses. Well, hopefully you can hear me. If you can't, I'm sure you're going to sign off soon, and then I'll know afterwards, but I won't make everybody sit and wait. Hopefully you can hear me. So getting back to what to expect, on the chat panel where you can message me, there's a place for questions. I urge you to write questions down as we go. I won't be reviewing or responding to them until the end of the webinar, but I will take as much time as necessary to respond to all of them. So put them down so that you don't forget them by the time we get around to it. There's also a handout that's attached to that chat panel, which I assume that you're able to download or print. This webinar will have several citations to statutes and cases that might be significant for you that many of my other webinars didn't have. So I'd urge you to take a look at that also. So let's jump into this and hope everybody's hearing me. All right, so the first tip, and sorry that the PowerPoint isn't numbered because it's supposed to be 12 tips. I'm assuming it is. I didn't go back and count them, but discuss needs for experts for alimony purposes. So a lot of people want to believe that non-traditional families are the most common forces that we see, raising the most unique issues, which is accurate. But longer duration marriages tend to have more of a traditional family structure. One parent or one spouse parents the children, maintains the house. One parent is, or one spouse is the main wage earner. There's a lot of considerations when you look at experts. There's going to be things like employability and lifestyle analysis that may be more significant in a longer duration marriage or in a marriage with older spouses. I want to also look at the alimony statute, which I cite here is NJSA 2A:34-23. Just run that into any basic web browser search. Significant aspect to the alimony statute, it was revised in 2014 to remove what used to be called permanent alimony, because it wasn't really permanent. It was permanent until a substantial change or until retirement. So they recognized that ambiguity, they took it out. But they also made it easier to seek a modification in the event of many different circumstances. The reason was, in the past, like I said, it was called permanent, but it wasn't. Any material change in circumstances like retirement, cohabitation, and change of circumstances were always reasons to change or modify or eliminate your support in practice, but not according to the statute. So now the statute does actually outline these with great detail, which we'll go into a little bit more thoroughly throughout this webinar. But it is important to look at the webinar. Yeah, I've been doing this for a while. To look at the alimony statute, just to become familiar with those terms. It's actually very lengthy now compared to how it used to be, but it's got a lot of detail that's important for everybody. So let's continue on a little bit with the experts for alimony purposes. First, you want to learn and discuss the different types of alimony that exist so you understand whether you're receiving or potentially paying it. There is open durational, which is what we use to replace permanent, which just means the duration is open. That's the term. Limited duration alimony, probably the most common, especially since the 2014 change. This is appropriate for marriages under 20 years. The way the alimony statute worded right now is if you're married it says your alimony can't be longer than the marriage if you're not married longer than 20 years. It doesn't actually say if you're married more than 20 years, it can be longer than the term of the marriage. It's an ambiguity that I've been waiting for to get addressed. I haven't seen it so far, but it basically only reads in one direction, meaning if it's not more than 20, your alimony can't be more than 20, which is good. And there's a catch-all absent extraordinary or exceptional circumstances. Many statutes have that kind of a catch-all phrase. Rarely applicable, rarely understood because it's rarely used. But it's important in case you do happen to have one of those circumstances that could be exceptional. Most commonly, they are where there's significant age difference. There could be disability issues or special needs that could become or be considered exceptional. I'm going on to the other kind. So there's rehabilitative, which is what used to be the more common alimony, and that is to help people who have been economically disadvantaged by being married, economically disadvantaged, for those that have other beliefs for disadvantages in their marriage that may be at this point. Rehabilitative is a plan and a term to allow them to get back into the workplace, get new skills, new education, and to try to put them back where they used to, where they would have been had they not been married. It's usually not as long as a limited duration term. And all of these can be, or not all of these, but you can have more than one. You don't necessarily have to have a limited duration for a period of time or rehabilitative for a period of time, but it could be either one or both. Reimbursement alimony, I list this because I have to. It is a term of alimony. It's the least common. I've alleged it, a complaint many times, and I don't know if we've actually ever pursued it. Reimbursement alimony is a sort of a repayment when one spouse has contributed to the other spouse's acquisition of an asset during the course of the marriage. What that means in most common examples is one spouse getting an advanced degree or training during the course of the marriage, which was paid for by the other spouse. That spouse who got the degree now has this valuable asset, will allow him or her to earn a lot more money after the divorce. Reimbursement alimony was intended to allow the person who paid for it to get some of the money back since the other spouse is taking the asset with him or her after it. Another type of alimony is pendentia liti. That is Latin for while the matter is pending. It means temporary alimony that will cover during your divorce case. The important thing to know about that, again, back to the 2014 changes, now when you pay alimony during your divorce, then it's applied to reduce the term you could be required to pay or ordered to pay at the end of your divorce. On the same lines of understanding these types of alimonies, do you need for an expert? If there's a self-employed spouse or a business interest that's being run, you may need a forensic accountant, not just for alimony purposes, but also for lifestyle analysis and for cash flow and value of that business. All right, so build in provisions in your divorce agreement for retirement. Next tip. So the current alimony statute, I'm going to start saying that because I keep saying the 2014 amendment at this point in time. Now that the statute does contemplate and provide for retirement at the federal age of retirement, which I think is 67. So first, let's look at this a little more closely. So you want to build into any divorce agreement, make it easier to retire. Just because the statute says that you can at a certain age doesn't mean that that's the end of the inquiry. And a lot of people can't and don't wait until 67 to retire. So if you're going to be seeking it before that age, you might want to contemplate putting some terms into your settlement agreement, assuming that you're going to make a settlement agreement and not be court ordered, so that the issue of retirement is understood at the time of your divorce, not when you later decide to retire. You also want to make sure to avoid what I call double dipping of retirement accounts, income from real estate or businesses. Although it's a little more intricate than I can go through in this webinar, alimony is based on your receipt of different, can be based on your receipt of different forms of income. You can get it from you can get it from retirement accounts, you can get it from real estate, business interests. But at the same time, you're likely to be dividing these interests up as an asset in your divorce. So you want to make sure when you're talking about settlement that you're carefully analyzing which sources of income do get counted for alimony, what sources of income are excluded from alimony. For instance, I have an example in my PowerPoint here. If you're already retired and you're paying alimony based on the retirement account, you could have agreed to an alimony amount because you knew you were getting a pension. Then there could have been a marital component to the pension that gets distributed inside of your divorce settlement. There could also be, and I've had this in a couple of cases recently, welcome to a couple of people signing on. Good to see you, sort of. I see you. I don't know how much, well, I guess you see me even more than I see you, but the support. Hope the information helps you, and I'm going to get back to the webinar. Now, here is what I was mentioning earlier, some of the sites that might be important for you. So here is the lead case that talks about double dipping when it comes to setting alimony and having your retirement accounts and other assets be protected so there's no double dipping. Next tip is to understand the different retirement accounts. Not only understand what you have, but to understand the tax consequences and all the legal issues that you're going to be dealing with. So let's take a look at some of them now. Okay, so the first thing you have to understand is your retirement accounts that are marital will be distributed in your divorce. If your retirement account is in pay status, that is not likely to be distributed as an asset, but it would be likely income for alimony purposes. I guess it would be possible for some plans to distribute it as an asset, and the source of income that you are receiving from it is going to be greatly reduced. Or you could actually become a possible candidate for alimony because your income is now being reduced. You want to understand the tax consequences. Generally, there's not going to be a tax consequence, the transfer or division of any of your retirement accounts. The only time you're likely to incur any tax trigger or consequence is when you take the money out, especially if you take it out prematurely, which I won't go through each different type triggers for that. But if you remove certain accounts prior to retirement age, you trigger a tax consequence. If you liquidate, sometimes if you roll over your share, but you don't do it in a tax-exempt account, you can be taxed on it. Generally speaking, if you're dividing assets that are retirement accounts in your divorce and they're done properly, not going to be any tax consequence to the division, the separation. Next, I'm going to give you the IRS tax code of 1041 to read. You'll need to understand things like quadros, qualified domestic relations order. That is the court order that needs to be entered by the judge in your divorce case. Later gets filed with your employer that allows the employer to divide your retirement account up so that the other party or spouse can get his or her share. Without the quadro, it's not going to be accomplished. And it's important in the beginning to know that quadros are considered like simple, matters, but they often become very complicated to accomplish. I'm not going to go through all the issues. I might actually consider doing webinar on quadros in the future, even though as dry of an issue as that is, there are a lot of issues that you should be aware of with quadros that I won't get into tonight. The quadros language has to match what the employer requires, federal guidelines require if it's an ERISA qualified plan, and what the court's going to require to enter it. So normally what I recommend that people do, and this is what we do in our cases, is we contact the employer at the beginning of the divorce case and say, look, there's going to be a quadro at the end. Send us the language that the company approves of so we can work it into our agreement. Sometimes they even have a form you can utilize, which saves a lot of time and trouble because, again, you don't want to draft something that doesn't match their language. That would be a big waste of time. Similarly, you have to understand the issues inside of your quadro, like what happens if somebody predeceases, is there survivor benefits, the cost of living adjustments, all that needs to be resolved. You also need to make sure that the agreement and the language that you use to resolve it matches the terms, language the employer requires. It's really something that you should be doing early into your case, and a lot of lawyers that I work with don't do it at all, and they leave the client to do it after the divorce, which can just be a very complicated, messy thing to do. So enough about quadros. Like pensions, simple issues. There's usually two kinds, kind that you contribute into, and maybe there's a match, and how much you contribute into determines how much you have and the value of it, absent market changes. Then there's another kind that's based on how long you have been with the company or how many years you've served, and your payment is based on a mathematical equation. Important to know which one you have because they divided differently. They also have different values financially and sort of mentally for people, because the latter doesn't necessarily have as much of a cash aspect to it, immediate term. And that might be an important information when it comes to your settlement terms. 401ks are almost like bank accounts. I mean, they're cash value. They are easy to divide. You can roll them over into another account. You can even just clean them out. But the 401k is one of the main accounts, main types of assets that have a significant tax trigger if you take it out prematurely. So you want to make sure you understand that. IRAs, similar to 401ks, both in a tax consequence, how you divide them up. You do not need a quadro for a 401k or an IRA. Some people will say that they think you do, but they don't. Just mistaken. Bank accounts, obviously, every time I'm planning through a simple bank account or a custodial account, not a custodial account, the word's escaping me. And then there's stocks. Common sense. All right, so next tip is understand Social Security and the 10-year rule. And this will help you not only understand Social Security, but why Social Security will not likely last for very long. So the 10-year rule basically says you're automatically entitled to a spousal benefit based on the earnings of your ex-spouse if you were married to that spouse for 10 years or more, and both of you are at least 62 at the time that you're receiving the benefit. The reason why I say that this rule will help you understand why Social Security is not likely to continue forever is the benefit that the second spouse receives does not reduce or diminish the first spouse's Social Security benefits. Meaning, if you're the main wage earner and you're getting $100 for Social Security every month, and your ex-spouse was married more than 10 years, let's say he or she's getting $50, you'll still get your $100, just the other spouse now gets $50. And that's not a system that can work. There's no way that a system can pay two people based on what was originally the earnings of one, which is what Social Security was originally created to be, and giving the fact that year after year, fewer children are being born in this country, and those next generations are the one who funds the last generation of Social Security, math just doesn't add up. That's kind of my own little soapbox, so I won't spend a lot of time on that. We just go both spouses to be 62, which I mentioned. Anybody new? I see an old client. Good to see you again. All right, so let's move to our next tip. I don't have the count. Let's say this is like 4-ish. Discuss lump sum alimony buyouts and cohabitation clauses. All right, so there's pros and cons to alimony buyouts and cohabitation clauses. First, the advantages gives you closure. A lot of people don't want to be writing a check every week, every 2 weeks to their ex-spouse, especially if they're moving on. They may get remarried, have another family. Certainly don't want to be paying the bills of their original spouse. And you usually are going to pay less upfront than you would long-term because you're going to reduce the long-term dollar because of the current present value discount. Meaning, if your alimony was going to be, I'm making up numbers, $200,000 over 10 years, you paid $100,000 now, that $100,000 will earn interest over the next 10 years. So it would make taking $100,000 manageable or realistic because you're not losing that much because you're getting the future earning potential of that money. Cons, I more often recommend against the buyouts because I think the cons outweigh the pros. But the first one is you lose out your ability to modify if there's ever any change of circumstances, which would include your spouse's remarriage, habitation, change in your or her earning abilities, death. All these reasons would modify or terminate your alimony. So let's say, for instance, in the $200,000 example I gave you, you write a check for $100,000, your spouse remarries or dies the next day. You don't get any of that back. And that's a big gamble that you're paying, that you're taking. So I generally don't recommend it. That's just kind of my own personal position. You have to always decide what's going to be best, and you should weigh both of these sides when making that determination. Along the lines of lump sum alimony and cohabitation clauses, cohabitation was added to the alimony statute again in 2014. Let me just take a second to put that number citation back up for you, 2A34-23. And I put that up just so that because you can type that into the web browser and you'll actually get the statute. So it's easy to pull up the information and get a hold of it. But the interesting thing about the cohabitation clause in the current alimony statute is, so let me step back. The way cohabitation used to be before it was codified in the statute was if it wasn't in your agreement and there was cohabitation, you could file, and if you could prove it, alimony was either reduced or terminated. Now, they did something that I think was astonishing. They amended it, and something I don't support whatsoever. But the statute now says if you can prove cohabitation, you can modify or terminate your alimony. If the other spouse stops cohabitating, he or she can reinstate the alimony. And I just think that's ludicrous because it's worth taking a chance. So if you are getting alimony and you remarry and you get caught, you lose your alimony, then you just say, all right, get out for a couple months, file to get your alimony back, and court might reinstate it. Obviously, you would think good faith, fair dealing, perjury issues, but the reality is, theoretically, you could still do it this way. And if you didn't plan it necessarily, I mean, you might just decide it's not financially worth it and have the person move out so you can get your alimony reinstated. I think it just puts an ambiguity and a lack of finality to the issue that didn't exist before. I don't really know why they did it this way, but they did. So I think there's a lot of value in actually having clauses that talk about modifying or terminating at cohabitation. First, you want to say what's going to happen at cohabitation. Is it going to terminate? Is it going to be modified? You have to go to a hearing and it be reinstated. You can agree to deviate and what the statute says about how cohabitation is treated. So the part that I was just talking about, you can agree that doesn't apply. I think you should agree it doesn't apply. I think it's bad for both sides to have this uncertainty about what's going to happen. The reason you have an agreement is so that you can get certainty. And the reason why I spend so much time on this, as my PowerPoint shows, this is a big issue because cohabitation is very common. And aside from the burden of proving it, you have to prove it's what's considered a marriage-like relationship. It's not just if I had this actually just come up recently in the case. I had an ex-adversary spouse who got alimony, moved her mother into her house. Now, cohabitation is usually defined both under the statute and in many settlement agreements as a marital-like relationship. And that marital-like relationship has to have some kind of financial either detriment or benefit to the relationship. When you move in a family member, that's not necessarily going to trigger a cohabitation clause. It may still have the same financial effect the cohabitation agreement would have. You get no relief from the court. So you can again deviate from that by saying she cohabitates, or she, I say she, because I do men's and fathers' rights. So no offense to any of the women that are watching or listening. But you can define your cohabitation provisions to exclude that definition of a marital-like relationship and have it just be anybody that moves in is contributing to the finances or incurring an expense to be considered cohabitating. One quick point on that, the reason why I spend so much time stressing this is cohabitation is very, very challenging and costly and long. And often because of that, a burden for many people to even get to the point where they get relief. Then if you're able to get relief and their spouse, let's say she, their spouse then just, takes the person out and wants it back, you spend all that time and money, and you're right back where you started from. It's just a horrible situation for you to be in if you're paying, even for the other person to be in it if they're the one playing the games, because it's just a lot of money and uncertainty to it. Not how people want to live. All right, next, you want to understand the rights and obligations for your children that are generally going to be older, and obviously we're not talking, sometimes they might be, like grown 30, 40-year-olds, but a lot of times people will have children later in life. They may have had them in their second marriage. So I have a lot of clients who are in their 50s that have college-age children, sometimes even younger. So first thing to understand when it comes to obligations for all children, but again, we're going on the assumption that they may be at least grown. We're not talking infants in most cases. Not all of them will go to college, and not all of them you'll be required to pay for college. But until they are emancipated, they are still under your financial and legal obligation. So you could have an 18, 19, 20-year-old not in college after a divorce, and they're not going to be removed from your child support until the court considers them to be emancipated or sort of on their own. But while I said you're not always going to pay for college, you can be responsible for college. I have an issue with the way most courts decide college contribution right now, because I believe still that it's luxury, not a right of children. I had a judge recently tell me just the opposite, that it's a child's right, not a luxury. And of course, I don't think he was right. I still don't think he was right. But in my practice, I see judges more often order child college contribution, even for modest income parents, because there are such widespread loans available. And it's often a huge financial burden. But there is specific law that's very fact sensitive. I'm putting this slide up here. It's Newberg versus Arrigo, 88, New Jersey New Jersey Supreme Court, 529, 1982, which means volume 88 New Jersey Supreme Court Reporter, page 529. If you just run those numbers again in a web browser, you'll get that. You can actually just run Newberg, W-B-U-R-G-H, versus Arrigo, A-R-R-I-G-O, and get the case. Sets forth the 14 things the court's actually supposed to consider before it can determine and award college contribution in favor of a child. Judges resist actually having these trials and going through these fact-specific issues, but you're right, I encourage you to utilize that carefully because the huge financial obligation. I mean, I've seen a lot of my clients who have modest incomes. They might be making 40, 50, 60, $70,000, which I'm sure to a lot of people in a lot of areas, that might be a nice living, not when you got to pay college. It's astronomical, and they take out hundreds of thousands of dollars of loans to do it. And it's usually just a burden that they can't manage. I see a bunch of my fraternity brothers signing on. Wow, a lot of people I haven't seen in a while. That's great. I see I haven't done this for a while. And it's nice to see everybody's coming back online. I haven't even been on Facebook for a while. I've been busy working at home, which is great. Thankful to have the work. All right, so more about the obligations to children. So the issues that you want to talk about, again, I always go on the assumption you're going to settle your case and not go to a trial. 99% of divorces do. So you want to discuss and understand how child support is calculated, how it gets modified, how it gets terminated, whether or not you need to go into court or not to do it. College contribution, like we talked about, you want to try to determine what that is likely to encounter. You also want very specific language that requires the child to obtain all financial aid, loans, grants, and scholarships available. And you want to make sure that you're involved in that process so you can make sure they are seeking to do it. Another thing I recommend clients put into their settlement agreement is to require that the child be responsible for payment of the loans that are received, even if the loans are in the parent's name. Now, there's a couple issues there. First, I don't know if the law is going to support that or not later, because you're binding your child to an obligation probably at the time that he or she was a minor, certainly not involved in the negotiations. Had to come up with other issues. Courts have decided against that. I still say put it in. One, might not get challenged. Two, the law may change, but it's significant. But also because the amount of loans that you may need to take out can be astronomical. And I think children need to have some skin in the game. I had school loans, and I think it was very valuable to have that obligation and to have to pay that obligation afterwards. But again, that's my own personal soapbox, just something that you should consider. You need to consider if you're going to have obligations for medical coverage, both for your ex-spouse, which normally is not going to happen. I won't go deep into why that is, or for your other children. And that's important because you may also be coming to retirement age or leaving your job or losing your job where you may be unable to provide medical coverage. So you need to be careful that you don't over obligate yourself to something like that. And also in here, I also mentioned extracurricular activities. That's usually not going to be a significant issue if you have older children, high teenage and beyond. Now, if you have younger children, it can be something significant. It is technically part of child support. So if you're under a child support order, you shouldn't necessarily be paying extracurricular activities anyway. You might want to do more for your children, but it's not a requirement. So understanding that distinction may help when you choose the number that you're going to be providing for it. Put in here, it still may be necessary to discuss legal and physical custody of your unemancipated children, depending again on their age and the issues that you have. It's important when it comes to things like school registration. It might be important when it comes to applying for colleges and where your residence is considered. So something you should consider. Lastly, with regard to children of a silver divorce, usually you don't need to have that rigid of a parenting time schedule. If you're talking about children over the age of 12 or 13, they're more often than not going to have their own schedule, their own plans and obligations. And usually you want to be a little more flexible so that they can come and spend time when it fits in their developing lives and schedules. Let's see how far we are into this. So we got some more time left, so let's just keep on. All right. So the next tip for men in a silver divorce is to seek mental health support. This may be a little more on the dark side. For those watching the PowerPoints, I hate and love these like dreadful little pictures, like the guy sitting there like his life is just coming to an end. I don't want to minimize. I mean, divorces can be a very traumatic experience, which is one of the first things that my PowerPoint, that for many, it's probably the most traumatic experience that they've gone through. I will say, as a caveat, as a person who's been doing divorces for 25 years, having been divorced myself, that almost everybody that I've represented has been happier after it, because it usually happens when it's at its worst. People usually come to me when their marriage is at the worst. So you really have no place to go but up. However, as you're going through it, it doesn't feel that way, which is why one of my most important tips through this webinar is to seek support from mental health counselors and therapists. In addition to just having your own mental health, you need to be able to make good decisions. You need to be able to be rational and planning long term. And if you're really, your head is not clear on these issues, you don't have somebody to help you sort of ground yourself, you may be in obligations or making decisions that aren't in your best interest. So I have a lot of clients who will come to me post judgment. They made agreements because they just were at the point where they said, I just want this over. I usually say that to a lot of my clients, like, your case will end when one of you says, I just want this over. You don't want it to be you. Because when you find yourself at that point, you'll sign and agree to almost anything, hoping and thinking that it'll get better. And again, men in their 50s often believe, well, they can handle it, especially if they're self-employed. In my experience, they believe, all right, well, I got this far, and what I did at work is going to make me successful in my divorce, so I can handle it. And it's not usually accurate. Hopefully it works, but it's not the same. But what may made you successful in your practice or in your areas of life doesn't necessarily mean it's going to make you successful in your divorce. So don't just agree to something because you want to get out and because you think you're going to be better off. It may not be. Hopefully you are. Circumstances change. It may not be foreseeable. You may find yourself in a very bad place because you rushed getting out. Financial stresses obviously are significant during and after the divorce. Not just the cost of the divorce. Often you have new expenses. You may have moved into a second home, so your expenses are double. You may be paying for your own maintenance and talking about alimony. A lot of financial issues can add to the stress of getting a divorce you need to resolve. Demands of the process itself can force you to need some mental health support. You will have court appearances where in the future and in our past, you had to take off work and you had to go and you had to sit and you had to pay for hours of time. You have discovery, you have to get documents, you have to exchange them, you have to get photocopies, you have to answer your questions and go to depositions. It's a lot. The average divorce case brings a lot of things that people need to do, practical aspects that you need to complete, that you may need some additional support just so you can manage that along with your other responsibilities. So in closing, to that point again, seek therapeutic counseling to help you get through the process. And quite honestly, probably after the process may help you too. Again, it's usually better afterwards. As you go through it, it's going to be tough. I want to scare people away. I don't want to make people think, well, you can't get divorced. It's going to be so horrible. But you need to be prepared for the challenges that you're going to face. See if we got anybody. All right. So another tip for men in sober divorces, which divorce over 50 years, and this really is a tip for anybody going through any divorce, at least those that have been married more than a handful of years. The first is plan ahead, especially when it comes to your documents. Most divorces are paper intensive, document intensive. Information that you're going to get and exchange and need to have usually is not going to be things you're going to testify about, but they're going to be tax returns and bank statements and deeds and retirement accounts. Those are documents that are almost always going to be required in any marriage, any divorce, no matter how long the marriage was. Now, the longer, the more likely you're going to have to get more documents. So, for instance, you may have credit cards and a home and a mortgage and a retirement account and bank accounts and credit card statements. And if you're only married 5 years, you may only need 1 or 2 of those years of documents, even at most. If you're married 25 years, you might need 10 years or 15 years. And maybe more challenging to get documents that far back. So the longer that your marriage is, the more likely you are to have a need for these documents, the more you should be planning as soon as you know it's going to be an issue to get them. You want to look for documents that will establish your marital lifestyle, credit card statements, car lease agreements, specifics about when and where you vacationed, how and where you shopped, who paid bills, are all going to be significant to determining the finances of your divorce. And depending on how you manage that, your situation may require different documents than others. For instance, you may put everything on credit cards. You have simple year-end statements you can use. You may pay everything in cash, and now you have to go and recreate all of it, try to get receipts, make up some kind of statement or journal of it. It's challenging. You want to start compiling them as soon as you know that you're going to be in a divorce case, whether it's been started or it's just being contemplated. Next tip, consider prenuptial agreements if you're going to remarry. I know most people who are in a divorce come to me and say there's not a chance in hell that I'm going to remarry. And many people say that, and many people find themselves remarrying shortly after their divorce. And I usually recommend that, especially if you had a long-term marriage, if it's a gray divorce, had substantial issues, you want to consider a prenuptial agreement. There's a lot of reasons for that. Let me just move the PowerPoint on a little further. Actually, you know what? I'm wondering if we should stop here. I'm only like 45 minutes into this, and I usually say it's an hour. I'm not going to get through all of this unless I tie everybody down for another like 40 minutes. And I'm thinking maybe considering how significant prenuptial agreements are, it might be a good place for us to break and up on another webinar. I'm sorry if that was going to be an important point for you, or if you are close to ending your silver divorce or consider remarriage. But I would rather not feel like I got to rush through the information. I don't want to keep you here for 2 hours. But I think it's too long. People on my YouTube aren't going to pay you that much time. And people, or my Facebook aren't, and YouTube, I don't think they like videos that are that long. So I'm going to now end the substantive part, take the last few minutes to see if there are any questions that are posted or if anybody has any questions. I really hope those that were tuning in can hear or could hear. Now it probably doesn't matter so much to hear, but let me see if I got any questions. Let me turn also to people. I think those that are watching me on Facebook can type like a question. And I think also here, you can't see one another unless you're mutual friends of one another. So you still have some confidentiality here. If you have a question, you can message me either through Facebook Messenger, my email, which you probably have, or even you can get from my website, which is brad@micklinlaw.com. So let me see if anybody took my advice to write down questions as we were going through this. I'm not seeing any, but that could also be because nobody could hear me. Well, most of the attendees that signed on originally are still here, so I have to imagine that they can hear me. And again, I think that nobody can see anybody else's name. I do see I have some clients popping on my webinar, which is great. This is why I do this. My YouTube page and all my webinars are intended to give people resources. You know, the challenge I see when people come to me for a consultation or even as a client, sometimes they don't even know what to ask because they haven't been through it. So they don't know what they're going to encounter. So I put these resources up so you can answer questions. You can dive into certain topics. I do short, long, and even some middle of the road tips and webinars so that you have resource. So getting back here, I don't see anything on Facebook. I can't see if we got anything here. I'm trying to open up chat box. It's not expanding. Right, so I don't see any. Again, if there was problems with the sound, I apologize. Like I said, I'm doing this from my house. It's probably first time since maybe now. I must have done a webinar or two from here. I'm in a different position in my house, different physical position. So I don't know if that's better or worse. So I apologize if you wanted to dive into this prenuptial agreement information. I will get to it. Hopefully, I don't think it's next month, but the month after. But in the meantime, you can message me in any platform that you have contact with me. My email is brad@micklinlawgroup.com. That's MICKLINLAWGRUP.com. It's also my website, same name. Those that have social media can message me through those platforms anytime that's convenient for them. And I think with that, I'm going to sign off. Wish everybody a good, safe evening, and I will see you, I believe, in 2 months for the rest of this webinar. Thanks for tuning in.